1.5 minutes remaining.
Thank you. I yield 2 minutes to the gentleman from New Jersey, Mr. Andrews.
The gentleman from New Jersey is recognized for 2 minutes.
I ask unanimous consent to revise and extend my remarks.
Without objection.
Thank you very much. I rise in opposition to the amendment. If a suspected terrorist can only be tried successfully in a military commission because there are concerns about jeopardizing the confidentiality of classified information or other concerns, then I emphatically agree that person should be tried in a military commission. But to presuppose that all such detainees properly belong in a military commission, I think is a mistake for 2 reasons. First, it really prejudges the record of evidence and the standing of law in that case when we're not necessarily competent to do that. That's a decision that prosecutors ought to make. And then secondly, I think, although it's not the intention of the authors, I'm sure, it belies a certain lack of confidence in our constitutional system of criminal justice. We should be proud of our system. It's one that operates on principles of fairness. It fairly and expeditiously determines guilt or innocence. And I think to abandon that system in all cases under all circumstances not only unwisely prejudges the facts of these cases, but also unwittingly undercuts confidence in our Constitution and our Article III courts. For that reason, I would urge a no vote on this amendment and yield back the balance of my time.
Gentleman from Florida.
Mr. Chairman, can I inquire as to time?
Gentleman from Florida has 1 minute remaining. Gentleman from Washington has 1 minute remaining.
Mr. Chairman, I reserve.
Gentleman reserved. Gentleman from Washington.
Is that correct?
Washington has the right to close.
Okay, then I will reserve.
Gentleman from Florida.
I only have 1 speaker left.
Gentleman from Florida is recognized for 1 minute.
Mr. Chairman, I would just say to some of the things that have been said that I don't think that what this amendment is saying is in any way disparaging what Article III courts can do or would be successful doing. And certainly I would agree that they could be adequate in prosecuting criminals and people that do crimes in this country. What we are talking about are foreign enemy terrorist combatants, people that commit acts of war against this country in furtherance of the authorization that this Congress passed. What we have done as a Congress is set up military commissions in ways that can protect evidence, ways that can protect witnesses and sources, in my opinion, in a way that the Article III courts might not be able to. I'm not saying that they couldn't. I'm saying that it's a better venue. Just like when we talk about earlier the Ranking Member Smith and Amash amendment, which would preclude the use of military tribunals, much as the Ranking Member is saying that options should be on the table, we're saying the same thing. And so with that, I hope people will vote for this amendment, and I yield back the balance of my time.
I yield myself the balance of my time.
Gentleman's recognized for 1 minute.
3 quick points. I think the difference here, and the reason that I drafted my amendment to say just in the U.S., I think is a legitimate point. Overseas, we do not have the same control over the investigatory process that we have here domestically. There's a clear difference between dealing with someone here domestically. That's why, in the last 10 years, we haven't done anything other than try people here in the U.S. under Article III courts. We haven't needed military commissions. That's why I think we should take that power away from the President, because it's an extraordinary amount of power to give him that isn't necessary. But overseas, they are, in fact, taking away the options in this amendment and saying it has to be military tribunals. And they are also saying that Article III courts are inadequate to do that, when, in fact, they've done it repeatedly. The people who committed the bombing against the World Trade Towers in 1993 were captured overseas, brought back, tried here in domestic courts. Article III courts work sometimes in these instances. Their amendment takes those options away completely. Also point out that Guantanamo Bay is not an enormous facility. They already have 40 people waiting in line for military tribunals. Many more will backlog that. But I want to come back to my amendment's going to come up later. Domestically, we have proven that Article III courts are more than adequate. Overseas, we've proven that we need multiple options. So this amendment sort of is in reverse of what the facts bear out that we should be doing, and I urge opposition to it.
The question occurs on the amendment offered by the gentleman from Florida. All those in favor say aye. Those opposed, no. Opinion of the chair, the noes have it.
Chairman,
Gentleman from
I
Washington.
do ask for a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Florida will be postponed. It is now in order to consider Amendment Number 8, printed in House Report 112-485. For what purpose does the gentleman from Maryland seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will designate the amendment.
In House Report Number 112-485, offered by Mr. Bartlett of Maryland.
Pursuant to House Resolution 661, the gentleman from Maryland, Mr. Bartlett, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from Maryland.
I yield myself such time as I may consume.
The gentleman is recognized.
Mr. Chairman, this is a very simple amendment. I would first like to make two statements that I think are generally recognized facts. One of those is that only 11.8% of our workforce belongs to a PLA. And secondly, that PLA contracts in the government, on the average, cost the taxpayer 12 to 18% more than a non-PLA contract. Our amendment is very simple. It is not prescriptive. It is simply permissive. It says that the government will not discriminate in awarding contracts whether you are PLA, not PLA, whether it's a mixture of PLA and non-PLA companies, that they will be considered equally and fairly. If, in fact, a PLA contractor is more efficient as they and does better quality work as they contend, then that will be taken into account in the award of the contract. You do not have to award to lowest bidder. You can award on the basis of best value. I think that this amendment is a common sense amendment that anybody who believes in a free enterprise system ought to support, and I reserve the balance of my time.
Reserves the balance of his time. For what purpose does the gentleman from Connecticut rise?
I claim time in opposition, Mr. Speaker.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Speaker. I rise in strong opposition to my friend Mr. Bartlett's amendment, which in fact does the opposite of what it was purported. Presently, the status quo allows the Department of Defense to have two choices. Yes, they can use a project labor agreement or a pre-hiring labor agreement that establishes terms and conditions of employment, or now they can elect not to enter into a PLA. The effect of this amendment would, in fact, remove the Department's ability to have a PLA requirement in terms of hiring terms and conditions. And the reason why those models work right now and have worked for decades is it gives the Department of Defense the opportunity to set conditions regarding security screening, apprenticeship programs, veteran hiring programs. I mean, the Helmets to Hard Hats program, which is one of the most successful programs of integrating veterans returning from Iraq and Afghanistan into the building trades, is done under a PLA arrangement. And it also allows local job markets to be incorporated into military construction projects. But again, the Department now presently has the option not to use PLAs. This amendment would, in fact, rob the Department of that opportunity, and I would retain or hold on to the balance of my time.
There's the balance of his time. Gentleman from Maryland.
Mr. Chairman, I yield 2 minutes to my friend from Arizona, Mr. Flake.
Gentleman from Arizona is recognized for 2 minutes.
I thank the gentleman for yielding. I rise in support of the Bartlett Flake amendment. Let me just clear something up if I can. What has happened, the President issued an executive order where he encouraged the federal agencies to, where they can, where appropriate, to employ PLAs. That might seem fine. The problem is some of the federal agencies have taken that to mean that they should require PLAs, and some of them have issued guidance to that effect. And so they have taken what the President said and taken it one step further. So what we're trying to do here is simply say that you cannot favor PLAs, nor can you prohibit them, that the federal agencies will be neutral in this regard. So to say that it would prohibit the use of PLAs is simply not true. We're simply trying to keep the President or the federal agencies from putting their finger on the scale in favor of PLAs or against them. So that's what this amendment does, and I'm proud to support it. Let me just say that this amendment was offered in the Appropriations Committee yesterday on the military construction bill and was passed by voice vote. There is a recognition that the President has, unwittingly or not, put his finger on the scale in favor of PLAs or union shops, and that's just not fair. The President and the agencies ought to be neutral in this regard. PLAs might make sense, they might not. What we ought to do is ensure that the taxpayer gets the biggest bang for the buck. That's the purpose of this amendment. That's why I support it. I yield back the balance of my time.
Gentleman from Connecticut.
Mr. Chairman, I yield 1 minute to gentleman from Massachusetts, Mr. Lynch.
Gentleman's recognized for 1 minute.
I thank the gentleman for yielding. Mr. Speaker, I rise in strong opposition to the Bartlett Flake amendment. This amendment would indeed seek to prohibit agencies from using a PLA, and it is not, as the gentleman from Arizona has just stated. Let me clear something up. Large-scale construction projects, look, I was an iron worker for 18 years. I have run work. I've been an iron worker foreman, an iron worker general foreman. PLAs are a great advantage to have in a complex construction project. This amendment and the PLA provision that's already in the President's executive order applies to projects that are $25 million and over. So all of those projects below $25 million don't get affected by the PLA executive order. What the PLA does require, as Mr. Courtney has pointed out, it does require compliance with statutory compliance with workers' comp law, statutory compliance with anti-discrimination law, with proper classification of workers, with health and safety laws on some very dangerous job sites. This is a good idea to reject the Bartlett Flake amendment, allow the PLAs to be used when appropriate. Thank you. I yield back the balance of my time.
Gentleman from Maryland.
Mr. Chairman, I yield 1 minute to Mr. Wahlberg from Michigan.
Gentleman from Michigan is recognized for 1 minute.
I thank the gentleman. Mr. Speaker, I stand in strong support of this amendment, an amendment that I think speaks to rationality of our contracting, and especially when we think of what we're talking about here in our defense world. It's one thing to have PLAs that virtually make unfair competition for 86% of all of our construction contractors, because 86% nationwide don't have PLA agreements, are non-union, and yet have skilled workers doing the jobs that are expected. For defense contracting to have a mandate that there must be a PLA agreement in place, oftentimes will put our defense industry at accepting a product that is more expensive and potentially of lesser quality in the process. This is not a mandate. This says choice can be made either way, and I think it needs to be made very clear. That's all we're saying. It is neutral. It is not, as described by others, that this would take PLAs out of the mix. I stand in strong support for this and ask that this amendment be applied and ultimately make a stronger defense capability for our country. I yield back.
Gentleman from Connecticut.
Mr. Chairman, I yield 1 minute to the gentlelady from Hawaii, who's a member of the Armed Services Committee, Ms. Hanabusa.
Gentlelady is recognized for 1 minute.
Thank you very much. I rise in opposition to the Bartlett Amendment because I think the Bartlett Amendment doesn't quite understand what a project labor agreement is and the difference between a collective bargaining agreement. This amendment targets the Executive Order 13502, which encourages the use of PLAs in construction contracts of $25 million or more. And the reason is that it's historically something that we have supported. Ironically, in 1992, there was a Supreme Court decision that defines PLAs, and it was called the Boston Harbor Agreement. It was under President Bush, who had a similar executive order that prohibited the use of PLAs. It was Bush's solicitor, Kenneth Starr, that argued for the PLAs. And he said the reason why you would use them is because of timely completion, labor peace and stability, labor supply, and for public purpose. This is the reason why you would use PLAs. What the Bartlett Amendment does is it will tie the hands of the Department of Defense, which we know historically has been one of the best ways to do these major construction projects. I yield back.
Gentleman from Maryland.
Speaker, may I inquire how much time remains?
Gentleman from Maryland has 1 1/2 minutes remaining. The gentleman from Connecticut has 2 minutes remaining.
I yield 1 minute to my good friend from Georgia, Mr. Gingrey.
Gentleman's recognized for 1 minute.
Mr. Chairman, I rise today in support of Amendment Number 8, the Bartlett Flake Amendment to H.R. 4310. The amendment will prevent the DOD from requiring contractors to sign expensive, union-favored project labor agreements as a condition of winning federal construction contracts for projects authorized by the bill. Under PLA, a construction firm must agree to sign a union collective bargaining agreement, whether it's unionized or not, before it can bid on a government project. PLAs can result in increased costs to contractors and taxpayers by as much as 18%, unnecessary procurement delays, and political favoritism in the federal procurement process. At a time when the Department of Defense is facing devastating across-the-board cuts, it simply does not make sense to encourage PLAs. And I urge my colleagues to support the amendment. I yield back the balance of my time.
Gentleman from Connecticut.
Mr. Chairman, I yield 1 minute to Mr. LaTourette from Ohio.
Gentleman from Ohio is recognized for 1 minute.
Thank you, gentlemen, very much for yielding. And we've seen this amendment a number of times in the 112th Congress, and sadly it doesn't get any better. It's based upon the misconception that somehow PLAs are costing the taxpayer money. The definitive research was done by the Department of Veterans Affairs that concluded it really depends on what part of the country you're in and whether you have a heavily unionized workforce in your area or you don't. They concluded that PLAs are productive and actually come in on time, under budget, in areas where you have a heavy unionized workforce and not so much in areas where you don't. And that makes sense because you got to bring people in to do the work. The amendment, I think, it's being billed as we just want people to give a choice, but come on. The people that are advocating this hate PLAs. They don't want PLAs. They want to kill project labor agreements. And so this was craftily drafted by the Associated Builders and Contractors to pretend that we're going to give people a choice when they really don't want people to have a choice. Please reject this. We don't have to go out, and the President's executive order is clear. All it says is you have to consider PLAs in the mix, and I urge us to reject the amendment.
Gentleman from Maryland.
Mr. Chairman, I have a long list of organizations supporting this amendment that I would ask unanimous consent to submit for the record.
The gentleman's request will be covered under general leave.
Thank you. Mr. Chairman, maybe it's because I'm a scientist, but I'm having some trouble understanding how an amendment that specifically says that it is non-discriminatory, that it's going to be totally agnostic to whether an organization is PLA or not PLA, somehow excludes PLAs from contention. That is certainly not what the amendment does. I think this is a very common sense amendment. I don't think that few Americans would like to exclude nearly 90% of American workers from contention for federal contracts. This is a fair, common sense amendment, and I urge its acceptance by both sides. Thank you, and I yield back.
Gentleman from Connecticut.
Thank you, Mr. Speaker. To conclude, again, there is a myth that somehow President Obama's executive order has swept through all the federal agencies and PLAs are now a mandated requirement. The fact of the matter is that is not the way the executive order reads. The Department of Defense has, in fact, granted only one PLA since President Obama's executive order was issued in January of 2009. As Mr. Lynch said, that executive order exempts projects $25 million or less. I'd be happy to invite members to my district to a military base where there's not been one PLA contract, although we've had a number of projects on our Navy base. So the fact is that the option exists today. This amendment would remove that option to the Department of Defense, which again has obviously exercised it very judiciously because they've only done one PLA since January of 2009. Again, I would urge members to reject this amendment, which handcuffs the Department of Defense to set up pre-hiring agreements that can help veterans, local workforces, and apprenticeship programs for young Americans who want to get an opportunity to learn a building trade. And I yield back the balance of my time.
Question occurs on the amendment offered by the gentleman from Maryland. All those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it. Gentleman from Washington.
Ask for a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Maryland will be postponed. It is now in order to consider Amendment Number 9, printed in House Report 112-485. For what purpose does the gentleman from Michigan seek recognition?
Thank you, Mr. Chairman. I yield myself 1 minute.
Does the gentleman have an amendment at the desk?
Yes, I ask that the amendment be reported.
Clerk will designate the amendment.
Amendment number 9, printed in House Report number 112-485, offered by Mr. Conyers of Michigan.
Pursuant to House Resolution 661, the gentleman from Michigan, Mr. Conyers, and a member opposed, each will control 5 minutes. Chair recognizes